So that's why confidentiality has to be maintained, because the whole purpose of mediation is to settle the disputes, come to the consensus. Parties should agree in the mediation. That, in fact, is going to help the broader purpose of the inauguration of mediation system, which is less number of suits to be remained pending before the court, as the courts are overburdened. So that whole purpose has been has been desired to be served if the mediation process guarantees the confidentiality, and that's why I think the provision is made in this connectivity. So as we also shared that the mediation or concerned legal aid officer, mediator or legal aid officer shall submit the report to the court as a result of mediation. If the result is of compromise between the parties, an agreement has to be made bearing the signature or left thumbs of the parties, and mediators or legal aid officers will be witness. So this is basically a formality how to continue and proceed with the mediation process. The court, after receiving the compromise agreement, pass an order or a decree within 7 days in accordance with the relevant provision of Order 23 of the Code of Civil Procedure. So once the parties agree to the terms and conditions and to their demands and other points, then certainly there will be an agreement written by the mediator, and then through formalities like giving the signatures of the parties, witnesses, the agreement will be sent to the court, and court, once received the agreement, it will give an order or a decree. So if you look at the definition part, it says that a judgment of a civil court will be either an order or a decree. Now, what is order? An order, what is the decree? We will be discussing in a different class. But please note that these are judgments. So the court will deliver its judgment either if it is an order or it is a decree. And that has to be in line with Order 23 of the Code of Civil Procedure. Now, taking the whole Order 23 would take much time. Rather, we choose to recite and highlight the relevant portions of rule of Order 23, and that is Rule 23. Sorry, Rule 3 of Order 23. Rule 3 declares where it is proved to the satisfaction of the court that a suit has to be adjusted wholly or in part by any lawful agreement, then by any lawful agreement or compromise, or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded, and shall pass a decree or order in accordance, a decree in accordance with so far as it relates to the suit. So I mean, the court, it is discretion provide, not discretion actually. It is upon the court to perform the task once the parties agree, a full agreement or partial agreement, whatever be, to the extent of their parties' agreement, the court will make its decree or order accordingly. So it says three things: lawful agreement or compromise, or where the defendant satisfied the plaintiff. Satisfaction means they can have some kind of conversations, and then they can have some kind of understandings that, okay, in this part they are not going to contest in the court process. So when the mediation is proceeded by the court, it shall prepare a report and pass an order accordingly. So if the court itself is a mediator, then it doesn't need to pass to some other courts. Rather, the judge himself will prepare the mediation. If the mediation fails to produce any compromise, I mean within the range of 60 days or 90 days, wherever applicable, the parties and the mediator they all set but could not come to a conclusion with regard to the suit process, then the court shall proceed with hearing from the stage at which the suit stood before the decision to mediate. So if we recall the previous conversations where we mentioned that after the written statements, when in the court everyone is available, both the parties and the pleaders and all others, then the court shall adjourn the hearing and it will start the proceedings immediately. So this adjournment of hearing was the point from when the parties went for mediation, but once if they fail in the mediation process, then the suit will exactly start from that stage. And the further proceedings shall be in accordance with the provisions of the Civil Code procedure in a manner as if there had been no decision to mediate or reference of mediation as aforesaid. So this is subsection 7 says that the presumption when the court will continue with the proceedings, the presumption will be that there was no decision of mediation at all. Rather, the suit continued from the beginning as it is. So this presumption has been in order to avoid the frustrations from the court, in order to avoid and ignore or disregard whatever be the complexities arising out, the tensions and the burdensome issues that the suit has to be settled accordingly. So there can be many more ramifications when a suit is not settled in mediation. When a mediation initiative led by the court itself fails to resolve the dispute or disputes in the suit. So if you remember, at the beginning we said that the mediation will be by several individuals. Firstly, the court itself can mediate, then it can send to a legal aid officer, then it can send to the pleaders, and or it can send to the parties, or in accordance with subsection 10, the district judge shall prepare a list of mediators. So if the court itself mediates, and if the mediation is successful, then certainly the court will give the decree or order accordingly. But if the mediation fails, then the question is, should the court continue the same suit? Because within the span of 2 months in the mediation process, the court knows everything about the parties, everything about the disputes, and the parties also shared the same. Although these cannot be later on used in the courts as confidential, but as a natural person, the court will have certain level of biasness to the party who actually shared the truth, or to the either party. So in such situation, subsection 9 of section 89A says that the same court shall not hear the suit if the court continues to be presided by the same judge who led the mediation initiative. So the point is, the same judge or same person who had been the mediator in the suit cannot continue afterwards with the suit. And in that instance, the suit shall be heard by another court of competent jurisdiction. So it's very simple that the court should not continue with listening to this particular suit, as it knows nitty-gritty and in details of everything about the suit, the parties, what is the disputes and all. Therefore, it is suggested that the suit should be transferred to some other courts if same judge remains in that suit. But it may happen that after the adjournment or after the mediation process, once failed, the judge may be transferred to some other court, but in this court another judge has been replaced, so he shall be able to continue the suit. As subsection 10, which deals with the mediation by the by the list of people made by the district judge. So that is provided in subsection 10, and we will come to that in next part.